Good morning, everybody. My name is Pranav, a legal intern at LEXIS and Company for the month of June. And today I will be talking about deductions from wages under the Payment of Wages Act 1936. Section 17 to Section 13 talk about deductions from wages made under the Payment of Wages Act 1936. Section 7 talks about the deductions which may be made from wages. Section 7 subsection 1 of the Act provides that notwithstanding the provisions of the Railways Act 1989, wages for employed persons shall be paid to him without deductions of any kind except those authorized by or under this Act. Now, what is a deduction? Explanation 1 of Section 7 subsection 1 says that every payment made by the employed person to the employer or his agent shall, for the purposes of this Act, be deemed to be a deduction of wages. Explanation 2 lays down that any loss of wages resulting from imposition upon a person of the following penalties shall not be deemed to be a deduction from the wages. Firstly, the withholding of increment or promotion, including the stoppage of increment at any efficient bar. Secondly, the reduction to a lower post or time scale or to a lower stage in scale. Or thirdly, a suspension. But these penalties shall not be deemed to be deductions provided that the rules framed by the employer for the imposition of such penalties are in conformity with the requirements of the Act. What is a permissible deduction? In view of Section 7 subsection 2, deduction from wages of an employed person shall be made only in accordance with the provisions of the Act and may be of the following kind, that is, a fine. Deductions for absence from duty. Clause B of Section 7 subsection 2 permits deductions for absence from duty. In Bank of India, Bombay and another versus T.S. Kelawala, Bombay and others, it was held that strikes and demonstrations are legitimate forms of protest and they are not banned in this country. By an administrative circular, the legitimate mode of protest is allowed and recognized by law. This cannot be stifled with. In Surendranath Nair and others was a senior divisional personnel officer, it was held that the leave rules to the railway employees are contained in the Railway Establishment Code and the rules made thereunder. The code derives its authority from Article 309 of the Constitution and the rules made under the delegated power. Deductions for recovery of loans made from any fund. Clause FF of subsection 2 of Section 7 provides that deduction may be made for recovery of loans made from any fund constituted for the welfare of labour in accordance with the rule approved by the state government. According to Clause FFF of Section 7 subsection 2, deductions are permitted for recovery of loans granted for house building or other purposes approved by the state government and interest due thereon. Income tax payable by the employed persons may be deducted from the wages according to Clause G of subsection 2 of Section 7. Clause H of Section 7 subsection 2 lays down that those deductions are required to be made by an order of a court or other authority competent to make such order from the wages of an employed person. Clause I of Section 7 subsection 2 lays down certain conditions which are required to be fulfilled before making any deductions for subscription and for the repayment of advances from any provident fund from the wages of an employed person. These conditions are: number 1, the provident fund must be made to which the Provident Fund Act applies, or 2, the Provident Fund must have been recognized by the Commissioner of Income Tax as defined in Clause 38 of Section 2 of the Income Tax Act, or the Provident Fund must have been approved in this behalf by the state government. Clause II of Section 7 subsection 2 provides that deductions for contribution to the National Defence Fund or to any defence saving schemes approved by the state government may be made from the wages of an employed person. That is, deduction must be authorized in writing by the employed person, or deduction must be authorized in writing by the President or the Secretary of the registered trade union of which the employed person is a member on such conditions as may be prescribed. Deduction for recovery of losses. The following deductions for recovery of losses may be made from the wages of an employed person in accordance with the provisions of the Act. Firstly, Clause M of Section 7 subsection 2 authorizes deduction for recovery of losses sustained by railway administration on acceptance by the employed person of counterfeit or base coins or mutilated or forged currency notes. Clause N of Section 7 subsection 2 authorizes deduction for recovery of losses sustained by railway administration on account of failure of the employed person to invoice, to bill, to collect, or to account for the appropriate charges due to that administration, whether in respect of fares, freight, demurrage, wharfage, and carriage, or in respect of sale of food in catering establishment, or in respect of sale of commodities in grain shops or otherwise. Clause O of Section 7 subsection 2 allows deductions for recovery of losses sustained by the railway administration on the account of any rebates or refunds incurrently granted by the employed person when such loss is directly attributable to his neglect or his default. Permissible total deductions. Section 7 subsection 3 lays down that the total amount of deduction which may be made under subsection 2 of section 7 in any wage period from the wages of any such employee shall not exceed, in cases where such deductions are wholly or partly made for payment of the cooperative societies under clause J of section 7 subsection 2, that is 75% of such wages, and in any other case 50% of such wages. If total deductions authorized under section 7 subsection 2 exceeds the limit of 75% or 50% of the wages as the case may be, the excess may be recovered in such manner as may be prescribed by the court. Deduction by an order of court. In Municipal Corporation versus NL Abhyankar, it was held that while it is correct that no deductions can be made from the wages of an employee other than those deductions which have been specifically set out in section 7 subsection 2 of the Act, Clause H of subsection 2 of section 7 clearly allows deductions which are required to be made by an order of court or other authorities who are competent to make such an order. Now, deduction with the consent. In Munsuk Gopinath Jadhav versus W.M. Bapat, it was held that there is nothing illegal in the action of the employer or the representative union in arriving at a settlement, and the clause in the settlement providing for deduction of certain amount and paying it to the employer's union. Moving on to Section 8. Section 8 talks about the fines. Section 8 lays down the general requirements for imposition and deduction of fines. Section 8 subsection 1 provides that the fine shall be imposed on any employed person. A notice specifying such acts and omissions shall be exhibited in the prescribed manner on the premises in which the employment is carried on, or in the case of a person employed upon a railway at a prescribed place or places. No fine shall be imposed on any employed person until he has been given the opportunity of showing cause against the fine. The total amount of fine which may be imposed in any wage period on any employed person shall not exceed an amount equal to 3% of the wages payable to him in respect of that particular wage period. No fine shall be imposed on any person who is under the age of 15 years. Section 9 talks about the deductions for absence from duty. Clause B of section 7 subsection 2 authorizes the deductions for absence from duty. Section 9 of the Act lays down that any such deductions to be made on account of the absence of an employed person from the place or places by the terms of the employment he is required to work. It is further provided that such absence may be the whole or any part of the period during which he is required to work. If 10 or more workers acting in concert absent themselves without due notice required by the terms of the contract of employment and without reasonable cause, such deductions may include such amount not exceeding his wages for 8 days and as may by any such terms be due to the employer in lieu of the notice. In GYN Chenulu and others versus the depot manager APSRTC Amalapuram and others, it was held that once a strike is declared illegal under Section 3 of the Essential Services Maintenance Act, a notice of strike issued under Section 22 of the Industrial Disputes Act is not due notice. The employer has the right to deduct wages in case of absence from duty without due notice and without a reasonable cause. Section 10 talks about deductions for damage or loss. Clause C of Section 7 subsection 2 authorizes deductions for damage to or loss of any goods expressly entrusted to the employed person for custody. Section 10 subsection 1 provides that any deduction under Clause C or Clause O of Section 7 subsection 2 shall not exceed the amount of damage or loss caused by the employer by neglect or default of the employed person. According to Section 10 subsection 2, all such deductions and realizations thereof shall be recorded in a register to be kept by a person responsible for the payment of wages under Section 3. Section 11 talks about the deduction for services rendered. Section 11 provides that any deduction under Clause D or E of Section 7 subsection 2 shall not be made from the wages of an employed person unless the house accommodation, amenity or service has been accepted by him as a term of employment or otherwise. In M. Balasundaram versus Financial Advisor Senior Railways, it was held that a condition precedent for the exercise of the power conferred on the employer under Section 11, Clause C of the Payment of Wages Act, it is necessary that there should be a requisition in writing by the local authority calling upon the employer to deduct professional tax from the salary or the wages of the employee. Section 12 talks about the deduction of recovery for advance. According to Section 12, any deduction under Clause F of Section 7 subsection 2 shall be subject to the following conditions. Firstly, recovery of an advance money given before employment began shall be made from the first payment of wages in respect of a complete wage period, but no recovery shall be made of any advance given for travelling expenses. Secondly, recovery of an advance of money given after the employment began shall be subject to such conditions as the government may impose. And finally, recovery of advance of wages not already earned shall be subject to any rules made by the state government regulating the extent to which such loans may be granted and the rate of interest payable thereon. And finally, the last section, Section 13, Deductions for Payment to Cooperative Society and Insurance Schemes. Section 13 of the Act lays down that any deductions under Clause J and K of Section 7 subsection 2 shall be subject to such conditions as the state government may impose. With this, I come to the end for today's discussion. Thank you.